All right, guys. So today we're going to be talking about how to escape the debt trap in 2024. Every Canadian needs to be aware of the following information. The banks have sold your debt to the world market, and with the right help, you can use this to your advantage. This guide will reduce your debt by thousands without affecting your credit score. Now, keep in mind, this is not a consumer proposal, this is not a bankruptcy, and there are no applications or upfront fees. If you guys have collection agencies calling you, this information will make them go away. If you guys are facing foreclosure, this information will save your house. If you're struggling with student loans, this information works to escape the struggle sooner. If you are thinking of bankruptcy or a consumer proposal, we can show you how to save your credit by asking the right questions. This is nothing more than understanding your rights at a pretty basic level. Consumer law. This guide has helped over 1,000 Canadians reduce their debt by thousands. To speak with our team, you guys can book a call at creditorcontrol.ca. Now, prior to 2008, nobody ever had to ask for proof of ownership of a debt when dealing with the banks. We've all been conditioned to believe what we were told. But after the banks admitted to selling people's debt irresponsibly and admitting that this was a reason for the crash, Canadians realized that they were being naive, not asking for verifiable proof if the banks are in fact the rightful owners of their debts. If you were purchasing a vehicle and the seller could not produce proof of ownership of the vehicle, would you hand them over your money? Of course not. The same premise holds true in the finance industry. Banks are taking full advantage of the general public not being informed by collecting on debts they sold and no longer own. Since the beginning of our company, we have realized that the information we share is almost completely unknown to the Canadian public. And we often get asked, why have I never heard of this? Aside from TikTok, YouTube, Facebook, and Google suppressing our message by shadow banning our accounts, when you go to the bank and sign an agreement for a loan, they hand you a long, confusing contract that's filled with legalese. That is a real word, and the definition is the formal and technical language of legal documents that is often hard to understand. Okay, the legal dialect of the English language. They intentionally inject confusion into the conversation, and then they add conflicting clauses into the agreements. And this agreement is no small deal. Everybody knows that debt is a liability to the consumer, but an asset to the bank. What people don't look into is what the bank actually does with your debt after the deal is done. What we're revealing is the dark side of finance, the side that isn't taught in schools or even to the bank's employees. These are the central banker's debt secrets. They are completely aware of everything we are revealing and they do not want you to know about it. Think about it. When you signed your loan, did you read the full agreement or did you sign where they asked you to sign? If you had read the terms and conditions, you might not have agreed to it in the first place. Every debt contract or loan agreement has the following clause. You should be able to find it in your own paperwork under the assignment clause. An example here from Fairstone's loan agreement state reads, we may from time to time, without prior notice to you or your consent, sell or assign any part of the entire new balance, debt, and any other obligations under this agreement. And this is what allows them to sell your business, your personal loans, your credit cards, your mortgages, and your car loans. This is the bank's best kept secret. You took out the debt, they sold it to another bank to get paid in full and even made a profit. They didn't bother to tell you since you signed where they needed you to sign, and you kept paying them every single month. They're getting paid twice. Even though they've sold your debt, they are legally no longer an affected party and do not have any right to collect payments as a creditor. So you might be thinking to yourself, why do banks sell your debt? In this link, Why Lenders Sell Mortgages, under the heading Why Loans Are Sold, it says many consumers don't realize there's a thriving market for loans, referred to as the secondary market. When you borrow from a bank or a credit union, you may not notice that the fine print on the lending agreement says that the loan may be sold. Most lenders sell loans due to liquidity reasons, meaning that they don't want the loans in their balance sheet, says Christina Zarilla, Assistant Vice President of the Mortgage Pricing and Investor Relations with Navy Federal Credit Union. They sell loans so they can lend to more borrowers. Some lenders sell loans but keep the servicing rights, meaning that you just keep sending the payments to the same bank. This is done intentionally. If you were constantly having to pay a new bank every month, every time it was sold, you'd probably wonder what the hell is going on. Instead, this way they make it easier on you, since the point of contact doesn't have to change. Here is some proof that the banks sell your loans. Here are 3 ways to quickly confirm your creditors sold your debt. If your name appears in all capital letters on any paperwork pertaining to the loan, then this means your creditor was planning to sell the debt from the date you signed the paperwork. In your loan agreement, it mentions the word assignment. The word assignment means your creditor was planning to sell your debt from the date you signed the paperwork. If you cannot find the word assignment in your paperwork, we would be happy to show you. Research if the banks sell debt by Googling "What is securitization?" or "Are my credit card debts securitized?" But we strongly suggest visiting and exploring our partnered humanitarian organization's YouTube channel, UnitedWeStandPeople.com. There, you'll find live footage of us dealing with your banks and their lawyers, and you'll be able to see irrefutable proof that banks are selling your debt. The following link is from Wikipedia, securitization, where the definition states clearly that securitization is the financial practice of pooling various types of contractual debt, such as residential mortgages, commercial mortgages, auto loans, or credit card debt obligations, and selling the related cash flows to a third-party investors as securities. In the following link, taken from Brown University Economics, the credit card asset-backed securities and their impact on U.S. household financial stability, it states clearly in the 3rd paragraph, securitization is the process of pooling liquid financial assets, such as loans, bonds, and mortgages, and selling the asset as liquid products to investors. It emerged in the 1970s and grew dramatically in the early 2000s. Furthermore, under the heading "To Background and Past Academic Papers," it clearly states the process of securitization is as follows. First, the originators pool a group of similar liquid and non-tradable financial assets, such as mortgages or car loan payments. Second, they transfer those assets to a company known as a special purpose vehicle, or an SPV, whose sole purpose is to issue the securities. Then, they repackage the cash flows through financial contracts with the different parties involved. According to Investopedia, transfer is another term for sell. Here are some key takeaways. A transfer is the movement of assets, funds, or ownership rights from one place to another. A transfer is also used to describe the process by which ownership of funds or assets is reassigned to a new owner. Banking, brokerage, cryptocurrency, asset titles, and loan transfers are a few examples of domains and transaction types where transfers occur. Here are some more links proving that the banks sell your debt. This link from the Financial Post states credit card debt is securitized. DBR's take on credit card debt and securitizations. This link, securitization, states in the 2nd paragraph, securitization is the practice of combining various debt obligations like residential mortgages, commercial mortgages, auto loans, or credit card obligations into one consolidated debt instrument or a security, such as a bond. Once the debt obligations have been pooled, a coupon is set and paid to the bond purchaser. By using the term purchaser, it proves that they are referring to the bank selling your debt. How the banks profit from selling your debt. Keep in mind, we are not referring to the bank selling debt if you went delinquent to a collection agency. We are referring to them selling your debt to a third party within hours of you signing the contract, well before the debtor could have gone delinquent. What they have no control over is who they sell the debt to. The entities that buy debts from banks advertise their services and products. We'll show you some of the sneaky ways in just a second. The products in this case is the debt itself, due to the fact they resell it for profit. The only way they can profit off of debt is by charging you compound interest. Understanding the difference between compound and simple interest is essential. So just to quickly show you how much more expensive a compound interest is, we went ahead and calculated a standard $20,000 loan at 19% over a 5-year term. Now, as you'll see, Taking these numbers and applying simple interest, your monthly payment comes out to $518.81. The total amount of interest you pay over the 5-year term is $11,128.66. And the total amount you pay back over the 5-year term is $31,128.66. Now, applying those numbers with compound interest, you'll see that your monthly payment goes from $518 to $855.51. Now, the total interest you pay over the 5-year term with compound interest becomes $31,330.75, making the total amount you paid back over the entire 5-year term $51,330 on a $20,000 loan. Clearly, compound interest is much more expensive than simple interest, about 40% more expensive. If you really want to see a person squirm in a suit, phone your bank manager and ask them to explain compound interest in relation to the amount of interest being paid on your loans. I am willing to bet the majority of readers who saw the words simple interest and compound interest initially had no idea of what the difference was, and because of that, have had little awareness over the implications it has had on their entire adult lives. But how about those of you who have been paying compound interest charges for years and years? Just imagine how much money you would have saved if you knew this information. If you didn't know this before, it's not your fault. Compound interest should be covered in detail with all students before they leave high school. The leaders of our school system were well aware we would be dealing with the banks throughout our lives. So ask yourself this question: why did they not teach us about compound interest and the banking system? The old saying, "The fox is watching the henhouse," applies to the bank's relationship with the general public. One of the bank's financial sleight of hand tricks that most people are not aware of is that when you borrow money from the bank, they charge you compound interest. But when you lend the bank money via depositing or investing money, they only allow you to earn simple interest. Knowing this, you would think the bulk of the bank's profit is made by charging people compound interest, but it is not. The bulk of their money is made by the bank selling your debt and not telling you. You created an asset the day you signed the loan contract. The asset created that day is the original wet ink copy of the loan agreement that you signed. Okay? The wet ink copy, that is very important, and do not forget it. Therefore, in our compound interest calculation, the wet ink original loan contract you signed for $20,000 is actually worth $51,333.75 over the 5-year term. This means the bank can now sell your $20,000 loan agreement for $35,000 via securitization, selling your debt to the world market. Therefore, the bank makes $15,000 within the half hour spent with you signing the loan agreement. This applies to all loans, even over the internet where they spend no time with you. Here are some examples. We've got LendDirect, Fora, Fairstone. All of these loans start at 20% compound interest and grow all the way to 46% compound interest. The kicker is that you can get approved for them through your phone. Keep in mind, none of this is taught in schools, and every year, the apps, the banks, the predatory lending facilities, they get to market to millions of fresh eyes and ears. Those people who are new to the system are young adults, new citizens, or people who have fallen into a financial drought. And since 2020, the economy has really been crushing the Canadian consumer with rising costs in groceries. Here's a chart illustrating the rise of cost in groceries, in mortgages. Canada's housing market is breaking records at an alarming rate. Sky-high prices, low mortgage rates, and short supply have yet to slow things down. The Bank of Canada began its recent rate hiking campaign in March 2022, raising its rate from 0.25% to most recently 5%, the highest in 22 years. Canadian lenders raised the prime rates they charge Canadian consumers in tandem, leading to the highest mortgage costs in years. Rent has also been rising. Canadian rental market faces a perfect storm as prices hit a new high in July. Here is a graph illustrating the rise in rent since 2018. Childcare has also gone up. How much does it cost to raise a child in Canada? Inflation has made daily living more expensive, especially if you have kids. Gas prices have gone up like crazy. In Calgary, Canadians are planning to hit the road for the last long weekend of summer, can expect to pay more for gasoline than they did last Labor Day. The national average gasoline price as of Friday was $1.67 per liter, according to the fuel price tracking website gasbuddy.com. This compares to $1.37 per liter on September 1st, 2022. Gasoline prices began to rise in July and August of this year, in part due to crude oil production cuts. Energy and utility prices have also been rising. Here is a graph illustrating the rising prices in different provinces and territories across Canada. Essentially, every aspect of life has gotten more expensive. The noose may seem to be tightening, but your debt doesn't have to keep getting charged compound interest unless you make the decision to keep it with a commercial lender, the bank. You can have a private lender agree to pay off your debt for you. Afterwards, they simply make a new contract between the two of you, and the bank is no longer involved. If you can find a private lender who's willing to reduce your current interest rates and charge you only simple interest, you can save yourself thousands of dollars. Our company was inspired by the 2008 housing market crash caused by the banks selling debt irresponsibly. We are a family-owned finance business focused on protecting the basic human right to due process of the Canadian public. Our team is led by Kevin Kumar, an expert in financial and consumer law with 3 decades of experience in the finance industry. He's put together a team of experienced professionals who provide better conditions for Canadians' consumers' debt loads. We understand how stressful it can be to deal with multiple creditors, and we want to help make the process as straightforward and stress-free as possible. With Creditor Control, you can rest assured that we will negotiate the best possible deal for you. Our experienced team is committed to protecting your fundamental human rights while helping you reach financial freedom and to get out of debt. Right now, we're focused on getting the word out to as many hardworking Canadians as we can, people that are struggling to put food on their tables while paying off their debts. You need to avoid predatory lending facilities. They are incentivized to maximize the interest in order to maximize the value of their loan. The more expensive they make the loans, the more profit they make. What separates us from everyone else is we will never charge you a dime for our time. Again, this is not a consumer proposal, and this is not declaring bankruptcy. This little known process is what's known as conveyancing, otherwise referred to as the financial dark arts, where we stop bank fraud in its tracks by simply exercising your basic Canadian human rights. This little known process is what's known as conveyancing, otherwise referred to as financial magic, where we stop bank fraud in its tracks by simply exercising your basic Canadian rights. You have the right to seek out a private lender. A private lender and you both hold the rights to ask reasonable questions about the debt that you will be forwarding funds for. You have a basic human right to due process, to simply ask the banks to prove to us that they didn't sell your debt, since we have the knowledge that they could have. And since we are all responsible Canadians, we of course want to assure that we are doing our due diligence to know with absolute certainty that we will be paying out only the rightful owner of the debt. That is the secret to Canadians to escape the debt trap in 2024. Requesting proof of ownership over your debt from your creditors. This will allow you to reduce your monthly payments, reduce your interest rates, and swap from compound interest to simple interest. This will allow you to save tens of thousands of dollars in interest charges, reduce your debt load from 25 to 50% without it affecting your credit score, and become debt-free sooner than you ever thought possible. The process of asking for proof of ownership of debt. The only entity allowed to ask a creditor for proof of ownership of the debt is you, the borrower, but only if you have the funds to pay out the loan in full, or you have a private lender who is willing to provide debt consolidation via purchasing the debt from your creditor. When you and a private lender ask for proof of ownership of debt together, it is a very powerful combination. Once you get partnered with a private lender to fund your debt consolidation loan, you will be provided the first registered letter to send to your creditors. If they do not respond within 20 days, we will send them a second registered letter. If they do not respond within 20 days of the second letter, we will send them a third and final notice. If your creditors cannot produce proof of ownership of the debt within 20 days of receiving the third and final notice, legally, this is proof that your creditor can no longer provide proof that they are the rightful owner of your debt. Once we have legal proof that your creditors cannot prove they are the rightful owners of your debt, we package and send all communications to the credit bureau, Equifax, TransUnion, and so forth. This is when the credit bureaus will contact your creditors, informing them that if they cannot prove they are still the rightful owners of the debt they have been reporting on, they will have to remove all negative remarks made to the credit bureau. As stated in Canadian legislation under the Consumer Protection Act of Canada, Canadian legislation states very clearly that all inaccurate information must be deleted from your credit report. The reports from your creditors who have sold your debt but still appear as negative on your report are by definition inaccurate information. So when supplying you a debt consolidation loan, we are not creating a new loan for you. We are buying an existing loan debt or an asset off of another company's books. We tell them that we have the entire balance and we are ready and willing to pay them out in full. But once we introduce our conveyance terms, you can see them in the blue lettering where the communication package states, this is a fact. Debts are bought and sold within the finance industry as a common daily business practice. Therefore, we are requesting proof of ownership of the debt. Insert your name has managed to arrange the funds to pay off the debt via a private lender, not a financial institution. Therefore, the following conveyance condition needs to be satisfied. Due to the fact that your creditors stated in the loan agreement that they were contemplating selling the debt from the date the contract was signed, insert assignment clause, please locate the original wet ink signed loan agreement, not a photocopy, and prepare for inspection, accompanied by a sworn affidavit by a chartered accountant verifying that the debt was not sold and still appears on your creditor's accounting ledgers as an asset. Due to this being a commercial transaction, we will need to be using commercial professionals, such as a chartered accountant. When purchasing any asset or debt, the asset must be inspected and proof of ownership must be verified before funds are forwarded. If the debt was sold, please inform us of who bought it. Together with the private lender, we can locate and continue the transaction with the rightful owner of the debt. Also, please provide an updated payout statement and a copy of the signed loan contract. This has become common practice since the great financial crisis, asking any and all banks or creditors to prove they aren't trying to collect on a debt which they no longer own. That would be fraud. And it's been 15 years of common practice. Yet I'm willing to bet 99% of people have never heard of this concept before reading this. The most important attribute private lenders are looking for when qualifying you is your ability to pay back the loan. Just as important, it is crucial that you understand the concept of asking for proof of ownership of the debt. The last thing that any of our lenders want to be is matched with a borrower who does not understand this concept. Think about it from their position. If it was your money and you were lending $20,000 to someone, you would want to make sure that you were handing funds over to the correct entity. When you ask your creditor for proof of ownership of the debt, but they cannot produce it, legally, they cannot collect. This creates a huge opportunity to reduce your debt by thousands while not having it affect your credit. And this is why it doesn't affect your credit. You are not negotiating with the banks due to not having the money to pay the creditors out. You are negotiating due to the fact the creditor does not have the correct paperwork proving that they are still the rightful owners of the debt. Really, at this point, you should be able to see how the banks have no right to collect anything due to the fact that if they sold the debt, they would have already got paid and no longer own it. If we were to forward them funds, they would have been paid twice. The truth of the matter is that the Canadian system is not ready to allow people to fully discharge their debts. But together with a private lender, negotiating a minimum 25% discount while being released from the compound interest trap and not affecting your credit report is a very realistic expectation. The same thing applies to collection agencies. Did the collection agency buy the debt or are they simply servicing it? There is a big difference. What collection agencies do is buy the file with your name, phone number, address, and employer. This is not the same as purchasing the debt. If they bought the debt, they would be able to produce proof of ownership of the debt, with being the wet ink original loan agreement that you signed, or a sworn affidavit from a chartered accountant stating that they own the debt. This, in fact, would be the document or asset that they purchased. If they merely bought the file, they have no legal grounds to collect. This can create a huge opportunity to reduce your debt by thousands. If the collector admits to not owning the debt, but is acting as an agent to collect, merely servicing it, the collector must be able to prove their client, your creditor, is the rightful owner of the debt. If the collector does not have proof their client, your creditor, is still the rightful owner of the debt, this is considered lack of due diligence on the collector's part. This would mean the collector is acting upon the simple fact your creditor told them that you owe them money. This is the same as calling up a collector and simply telling them you are owed money by an entity, and they start collecting simply upon your word. This is very unprofessional. We go ahead and begin the commercial communication with your creditors for you. And the first thing we do is send our communication package through registered mail to them. When the mail gets signed for, the creditors have officially received our proof of funds waiting and ready for the transfer. Think of the money being held in escrow until the other party meets the deal requirements. Remember, the bank doesn't have to bother with communication when they sell your debt to another bank. That is because this is an internal transaction within the central banking system. But when you come together with a private lender to complete the transaction, that is now an external transaction. And you have your fundamental right to due process, the right to ask reasonable questions and receive reasonable answers. Just to solidify the fact that your creditors could have sold your debt, every one of your creditors in the loan or credit card agreement state that they are contemplating selling the debt from the date the contract was signed. The following paraphrase can be found within each agreement you have signed with your creditors. Your creditor may, without notice to you or your consent, sell, transfer, pledge, or assign any part of this agreement to any third party. The above paraphrase, found within the client agreement, proves that your creditor was contemplating selling your debt to a third party from the date the contract was signed. Therefore, the documentation we are requesting is a very reasonable and simple request. Sometimes ignorant and uneducated creditors and collection agencies attempt to convince us that their internal company policy trumps Canadian rule of law. I will give you an example. Our partnership humanitarian organization, UnitedWeStandPeople.com, holds public live investigation series on their YouTube channel. And in one of their recent investigations, the CEO of Credit Club is being sued for damages by the Canadian public. The CEO had said, quote, "I'll go ahead and mark it as a missed payment because it doesn't affect me." Even though his company has signed for the registered mail, choose not to read the letters of communication we had presented to them, and waited until they received the third and final notice before they would have legally lost the right to collect, just to respond to us and begin communication. For a creditor to receive proof of funds in an external transaction with conveyance protocols and blatantly ignore the fact that they have legally received payment and proceed to report missed payment to the credit bureau is what is causing these damages. There is no need to worry, because at the end of the conveyance process, when your private lender has successfully bought your debt contract from your creditor and the process is complete, we have the paper trail with the date, stamps, and signatures to prove that we sent payment and they received the payment that was misreported. So all we have to do is package up that documentation and send it to Equifax and TransUnion to inform them of the illegal remarks and illegal predators that exist on your credit report. In summary, you partner with a private lender to create an external transaction and introduce particular conveyance requirements, requesting proof of ownership over the debt before the funds are forwarded. After the conveyance process is complete, you and the private lender create a new agreement between yourselves for you to pay off the remaining debt at a much lower monthly payment and interest rate, saving you thousands in both principal and interest. To make this work for yourself, there are a few ways. Option 1 is to try challenging the proof of ownership by yourself. However, this will likely fail, because if you successfully challenge the debt and manage to win in court, you are going to incur legal fees and then have to negotiate a settlement on the remaining balance with the creditors. So at that point, you'll either have to have all of the funds or a private lender and get them to agree to join you in court. And you will have to face multiple conflicts of interest during the legal process. And if you don't know how to navigate that, then you are at risk of being completely bulldozed and having your legal fees run up exponentially over time. Your second option is to work with our team and have us communicate with your creditors on your behalf, leaving you guaranteed to get the result for a fraction of the effort. This way, you know your financial interests are protected by our expert legal and accounting team. This is a completely free service where we back you with our expert legal and accounting team. We find one of our 2,500 plus private lenders to team up with you. We engage on your behalf with your banks and creditors. We make certain whether or not your debt has been sold. We guarantee to reduce your debt load by a minimum of 25%. And we save you thousands by negotiating that private lenders switch you from compound to simple interest. We will also provide you with all live recordings of every conversation that we have with your creditors. Now, some of you may be asking, are there any upfront fees? How much is this going to cost me? It is completely free. There are no upfront fees, application fees, legal or accounting fees, or any fees for you later on. If there are no fees, well, then how do we make our money? The private lender is the one who pays our fee, which creates an entirely free service for you. We do not make any money until we provide you with a 25% discount off of what you owe your creditors. Our fee is the percentage of the negotiated discount over and above the 25% discount that was guaranteed to you. If we manage to obtain a 30% discount while we settle with your creditors, we would make 5% while you retain and save the other 25%. If your debt is over $20,000, you can negotiate a larger discount than 25%. The more that's owed, the stronger your negotiation position is to get a larger discount from your new private lender. Now, what will your interest rates look like? We guarantee that when using a private lender, the interest rates you are paying your present creditor will be reduced. A common misconception within the marketplace is that private lenders charge higher interest rates than banks do. Considering credit card interest rates range between 17 to 34% of compound interest and payday loans are even higher, a private lender can easily beat these rates due to the fact the private lender charges simple interest and not compound interest. On the homepage of our website, there is a segment of a video you can watch that shows, in an entertaining way, how expensive compound interest is compared to simple interest. In general, when dealing with the bank, they will quote you a rate with a take it or leave it attitude, allowing little to no room for you to negotiate. A private lender will inquire about your file once it is on our system. With the help of your representative, we will negotiate the terms and conditions and interest rate of your loan with the private lender. This will guarantee you to receive a better rate than you are paying your current creditors. Now, why should I request proof of ownership of the debt? The borrower gets to know for certain that the lender has a legitimate claim to the debt. This ensures transparency and can prevent fraudulent lenders from taking advantage of borrowers. If you ever had a sneaking suspicion that your bank wasn't playing fair, here's your way to exercise your legal right to find out. Imagine you shine a light on a bunch of cockroaches and they scatter. Asking these bank lawyers to prove they aren't committing fraud stops criminal lending practices and promotes transparency in the financial industry. Ultimately, it protects your rights and ensures that your finances are handled fairly and accurately. Requesting proof of ownership also helps to prevent scams. In some cases, scammers may pose as legitimate lenders and offer loans to unsuspecting borrowers. By requesting proof of ownership, we simply make sure that you are dealing with a legitimate lender to avoid being scammed. To start this process yourself, go ahead and visit creditorcontrol.ca. Now, why must the sworn affidavit be from a chartered accountant? A chartered accountant is a professional accountant who has completed a specific program of study and professional requirements and has passed a rigorous examination in order to earn their designation. They are typically seen as experts in financial matters and are often called upon to provide financial advice and analysis. In this context, the sworn affidavit would be used to provide evidence in a legal proceeding such as a lawsuit or arbitration. The affidavit would be considered a statement of fact, and if it is determined that the accountant provided false information, they could be subject to jail time and other legal consequences, such as losing their license. Overall, a sworn affidavit from a chartered accountant that states they have checked the ledgers and the debt has not been sold is a legally binding statement that can be used as evidence in legal proceedings to confirm the status of ownership of a debt. What other documentation qualifies as proof of ownership of debt? Under the Bills of Exchange Act in Canada, proof of ownership of debt can be established through various forms of documentation. These include the original promissory note. And a promissory note is a written agreement that acknowledges a debt and includes a promise to pay the debt on or before a specified date. The original promissory note, not a photocopy signed by the debtor, can serve as proof of ownership of the debt. Or an endorsement. An endorsement is a written statement on a promissory note or other negotiable instrument indicating that the holder of this instrument has transferred it to another person. A valid endorsement can serve as proof of ownership of the debt. An assignment. An assignment is a written document that transfers ownership of debt from one person to another. A valid assignment can serve as proof of ownership of debt. Or a sworn affidavit from a chartered accountant. A sworn affidavit from a chartered accountant would be stating that they have checked the ledgers of a particular entity and can confirm that a specific debt has not been sold. Legally, what does the bank or any lender have to produce to prove they are still the rightful owners of the debt? There are two major items your creditor must produce to prove they are the rightful owners of your debt. Your creditor must locate the original wet ink signed loan agreement, not a photocopy, and prepare it for inspection. Your creditor must produce a sworn affidavit by a chartered accountant verifying that the debt was not sold and it still appears on your creditor's accounting ledgers as an asset. Keeping in mind, when your creditor cannot produce the aforementioned items, this is what allows you, together with your private lender, to negotiate a minimum 25% discount and release you from the high compound interest rate debt trap. The condition that must be satisfied by your creditors before you and the private lender will forward funds is very simply stated as follows. Please locate the original wet ink signed loan agreement, not a photocopy, and prepare for inspection, accompanied by a sworn affidavit by a chartered accountant verifying the debt was not sold and still appears on the accounting ledgers as an asset. The wet ink original contract you signed is proof that they are still the rightful owners of the debt. For example, if you signed the original contract with blue ink, the contract your creditors produce to prove they are still the rightful owners of the debt must have your signature in blue ink. The original contract you signed that has the blue ink on it is the asset your creditors could have sold. If your creditor can produce only a photocopy of the contract you signed, that is not sufficient. A photocopy of the contract you signed is simply a picture of the asset. It does not prove that they still own it. A good analogy is if you were going to buy a car from me and it was time to hand over the funds to buy the car, and you asked me for proof of ownership of a vehicle, and I responded, I do not have it with me right now, or I handed you a picture of the car, would you feel comfortable handing over the funds? Of course not, due to the fact that I cannot prove I am the rightful owner of the car. With that said, if your creditors can prove they are still the rightful owners of the debt, we will simply pay them out in full. If they sold the debt, we just need to know who they sold it to so we can deal with the rightful owner of the debt instead. If your creditors did sell your debt, they would have sold it to the world market, or in other words, they securitized your debt. When the world market resells the debt, the bank or the agent of the world market will not be able to produce the proper paperwork in order to prove who is in fact the rightful owner. Why is this? The bank will bundle 2,000 Canadian borrowers' loan contracts and sell them to the world market. The world market will in turn create asset-backed securities and sell the 2,000 loan agreements to 10,000 investors. To sell 2,000 loans to 10,000 investors means that they must cut each loan contract into 5 pieces and sold those pieces individually. Therefore, asking any entity to produce proof of ownership of the debt is impossible once your debt has been securitized. We will be able to analyze your debt to tell you whether or not it was securitized, sold to the world market, simply by filling out the secure application form here on our website. We will be able to analyze your debt to tell you whether or not it was securitized, sold to the world market, simply by filling out the secure application form here on our website. Does debt consolidation affect my credit in a negative way? No, debt consolidation does not affect your credit in a negative way. Debt consolidation is often confused with consumer proposals. Consumer proposals affect your credit in a negative way, while debt consolidation does not. There are illegal tactics that creditors have taken against our clients, but before we navigate this for you, please watch the following video to see the type of creditors we're going to be dealing with. What illegal actions do creditors sometimes take? We have 24,000 Canadians following our case against Easy Financial for illegally filing missed payment reports against our clients. They are illegal filings due to the fact that once we got the confirmation that they had received our registered letters of communication with the conveyance terms clearly specified within, that legally qualifies as having received payment. And all we are doing is we have made a reasonable request in due process before finalizing the conveyance. Anyways, thank you guys for sticking around. I hope you guys check out the website. This is probably some of the most valuable information that you will run into on this planet. Please share with your friends and families so we can really make a difference here. Thanks. You guys have a wonderful day.